Let's start with this chapter 5 questions. A scheme of amalgamation was approved by overwhelming majority of members of both the merging companies at the meetings called as per the direction of the tribunal. When the scheme of amalgamation was awaiting sanction of the tribunal, the exchange ratio was questioned by a small group of members of one of the merging companies. The exchange ratio was fixed by a reputed firm of chartered accountants examined by the tribunal leaves the respect of determining the exchange ratio to the expert valuers and shareholders. Unless a person who challenges the valuation satisfies the tribunal that the valuation is grossly unfair, the tribunal will not disturb the scheme of amalgamation. In this case, since the valuation is conferred to be fair by a reputed firm of chartered accountants and is also conferred by majority of members, the objection by a small group of shareholders cannot be sustained as held in Hindustan Lever Employees Union versus Hindustan Lever Limited. Section 230 subsection 5 requires that the notice of the meeting and all the prescribed documents should be given to the central government, and the central government shall have a right to make its representation within 30 days. The tribunal shall make into consideration the representation if made to it by the central government before passing any order, but the tribunal is not bound to accept the views of the central government. Hence, even if the representation is made by the central government, the tribunal will refuse to interfere unless the government establishes the exchange ratio was unfair and not in public interest. ટ્રિબ્યુનલ એવું નહીં અંદર વચ્ચે ઇન્ટરફિયર નહીં કરશે જ્યાં સુધી એને એવું નથી લાગતું કે આ પબ્લિક ઇન્ટરેસ્ટને અનફેર છે ક્યાં તો પબ્લિક ઇન્ટરેસ્ટને હેરેસ કરે છે ત્યાં સુધી ટ્રિબ્યુનલ ઓબ્જેક્ટ નહીં કરશે. Now, practical question 2. The shareholders and creditors of Supreme Limited in a company convened for approval of a scheme of reconstruction of the company passed resolutions. The scheme of reconstruction provided the following: sale of plant and machineries and appropriation of proceeds for payment of outstanding wages, taxes, dues, and repayment of loan. Unsecured creditors to forgive 60% of their claims against the company and receive debentures for the balance amount. A few shareholders and creditors raised objections against the said arrangement. Advise the directors about the step that they should be taken. As per section 230, the procedure to be followed by Superfy to give the effect. An application for a compromise shall be made to the tribunal by the company, any creditor of the company, any member of the company. અહીંયા કોણ આપે છે? Sale of land and appropriation of proceeds for payment of outstanding wages. Okay. The liquidator appointed under the company or any other person by whom an application shall disclose all the material facts on receipt of such the tribunal may face the tribunal on receipt of such application, the tribunal may order a meeting of the creditors or class of creditors or of the members or class of members as the case may be called or held and conducted in such manner as the tribunal directs. The notice of such meeting shall be sent individually at the registered office with the company to all the creditors or class of creditors or all the members or class of members or all the debentures of the company. Any objection to the compromise shall be made by the persons holding not less than 10% of the shareholding or outstanding debt amounting to not less than 5% of the total outstanding debt as per the latest audited financial statement. A notice along with the document shall also be sent to such sectorial regulators and authorities that are specified under section 230 uh, as per the late okay section 230. If any of the regulators need to make any representation, they shall do so within 30 days of receipt of notice, failing which it shall be presumed that they have no representations to make on the proposals. At the meeting held, majority of persons representing 3/4 in value in the creditors or class of creditors or members or class of members as the case may be voting in person or by proxy or by postal ballot must agree to the scheme. Thereafter, a petition shall be made to the tribunal for confirmation of such compromise or arrangement. The tribunal may sanction such compromise or arrangement if satisfied after considering all relevant matters. The compromise or arrangement once sanctioned shall be binding on the company and all the creditors or class of creditors and all the members or class of should be binding on the company and all the creditors or class of creditors and all the members or class of members. If the tribunal decision લેશે તો બધા પર binding થઈ જશે. The order of the tribunal shall be filed by the company with the registrar within a period of 30 days of the receipt of the order. આટલી procedure follow કરવી પડશે. આટલા 7 steps છે. પહેલું તો કોણ એપ્લિકેશન કરી શકે તે આખો સેક્શન 230 છાપી દીધો છે. ઇન શોર્ટમાં કઈ બીજું છે નહીં. સેક્શન 230 ને આખો વાંચી લેજે એકવાર એટલે આખો સેક્શન 230 છાપ્યો છે અહીંયા. A meeting of members of ABC Limited was convened as per the orders of the court to consider a scheme of compromise and arrangement. Notice of the meeting was sent to 1,000 members holding in aggregate 5 lakh equity shares. The meeting was attended by 800 members holding 3,50,000 shares. 450 members holding 2,40,000 shares voted in favor of the scheme. 200 members holding 60,000 shares voted against. The remaining 150 members abstained from voting. Explain with reference to the provisions. This three-fourths in value of the creditors or class of member, as the case may be, voting in majority of the persons representing three-fourths, or by proxy or by postal ballot, agree to any compromise or arrangement. The tribunal may sanction such compromise or arrangement. It must be noted that members of creditors who are not present in the meeting or who are present but abstain from voting shall not be taken into account for determining whether the requisite majority has been attained or not. Applying the above provisions in the given case, the 150 members who abstain from voting holding 50,000 shares, 150 members who abstain from voting holding 50,000 shares, therefore, will neither be considered for determining the majority number nor for determining the three-fourth value. In the given case, total 650 members have voted, out of which 450 have voted in favor. Thus, the approval is received from the majority in numbers, that is 326 or more of the members voting. Further, the total number of shares held by the members who have voted is 3 lakhs, and out of which the members who have voted in favor held 2,40,000 shares. Thus, the value represented by members who voted in favor is more than three-fourths of the total value, that is 2,25,000 or more. Therefore, the scheme has been approved by requisite majority as per section 230. હવે આમાં કેવું છે જો મેજોરિટી આપણી પાસે કેટલા છે ઉપર આઈરો ક્વેશ્ચન પાંચ ધ મેમ્બર્સ હુ અટેન્ડેડ મીટિંગ 800 મેમ્બર્સ હતા તે લોકો પાસે 3.5 લાખ શેર્સ છે ઓકે પછી એમાંથી 450 મેમ્બર્સ પાસે કેટલા છે 2,40,000 છે 450 મેમ્બર્સ પાસે 2,40,000 નંબરના શેર્સ છે અને આ લોકોએ ફેવરમાં વોટ કર્યું છે ઓકે પછી 200 જે છે તે લોકો પાસે 60,000 શેર્સ છે અને તે અગેન્સ્ટમાં વોટ કર્યું છે અને રિમેનિંગ જે 150 છે તે એબ્સ્ટેન થઈ ગયા આટલી આપણી પાસે વસ્તુઓ મળી છે તો હવે એબ્સ્ટેન વાળા છે તે કેટલા છે એટલે 3,50,000 માઇનસ 2,40,000 માઇનસ 60,000 એટલે આવી ગયું 50,000 શેર 150 મેમ્બર પાસે 50,000 શેર છે એટલે આ તો આપણે કાઉન્ટ કરવાના જ નથી હવે આપણે 650 650 છે એની મેજોરિટી થશે 326 મેજોરિટી થશે હવે આપણી પાસે તો 450 છે એટલે પહેલી કન્ડિશન તો પ્રોપરલી અપ્લાય થઈ ગઈ આપણી ઉપર એટલે એ તો વાંધો જ નથી પછી 10 વેલ્યુ એટલે હવે આ જે 3 લાખનું શેર છે 3 લાખ 3 lakhs ઇન્ટુ 3/4 ની વેલ્યુ હોવી જોઈએ એટલે 2,25,000 આવી ગયું 2,25,000 થી વધારે જો વેલ્યુ હશે તો આપણે કરી શકશે તો 2,40,000 the scheme has been approved by requisite majority બરાબર 4 practical question 4 in the context of judicial rulings in the matter of merger answer the following whether the transferor company is justified in excluding assets held on lease and license agreement from those transferred to the transferring company as per the decided law in Hindustan okay the court said that the assets held on lease and lease agreement were neither transferable nor heritable. They are in the nature of a personal privilege. The facts of the case are as under scheme of amalgamation provided for transfer of all the assets, properties, undertaking, and liabilities of the transfer company, that is Tromco, to the transferring company, that is Hindustan. However, there are three properties which were not to be transferred to Hindustan. It was held by the Supreme Court that these three properties were being used by Tomco purely under the gratuitous license with no enforceable rights. Tomco had no right, power, authority, or privilege over such properties. The owner of such properties could at any time revoke the permission to use given to the Tomco. These properties were not included in the balance sheet of Tomco, thus there were no malefices in excluding these properties. Therefore, from the above ruling, it can be concluded that the transferor company is justified in excluding assets held on lease and license agreement from those transferred to the transferee company. કે લીઝ વાળા છે તો એની પાસે તમારે લાયસન્સ ને એવું હોય તો તમે કરો તો બરાબર છે પણ આ તો તમારું ગ્રેચ્યુટિયસ વાળું છે કઈ છે નહીં પ્રોપર ડોક્યુમેન્ટ્સ અને તમે એને તમારી બેલેન્સ શીટમાં બતાવો તો એ પ્રોપર નથી એ નહીં કરવું જોઈએ. ચાલ practical question 5. Sunrise Company Limited was merged with Moonlight Company Limited on account of amalgamation. Some workers of Sunrise Company Limited refused to join as workers of Moonlight Company Limited and claim compensation on the grounds of premature termination of their services. Moonlight Limited Company resists the compensation on the ground of premature termination of their services, or resist the claim of the workers on the ground that the services have been transferred to Moonlight Company Limited in view of the order of amalgamation and merger, and hence the workers must join the service of Moonlight Company Limited and cannot claim any compensation. State the powers of the tribunal about the matters that would be considered while sanctioning the scheme of amalgamation under the provisions of Companies Act 2013. Decide whether the contention of the workers is justified. As per Section 232, if the tribunal is satisfied that the procedure specified under this section has been complied with, it may by order sanction the scheme of amalgamation. Where an order under this section provides for the transfer of any property or liabilities, then by virtue of the order and without further documents that the property shall be transferred to the transferring company, the liabilities shall be transferred to the shall be transferred to and become the liabilities of the transferring company, and any property may be, if the further as per Section 2, while approving the scheme of amalgamation, the tribunal may also make an order of the transfer of employees of the transferor company to the transferring company. The tribunal makes an order that the services of workers of the transferor company shall be transferred to the transferring company. Such transfer of services shall be binding on all the parties, that is, the transferor company, the transferring company, and the workers. Accordingly, if the tribunal makes an order for transfer of services of workers, but the workers refuse to join the services of the transferring company, the worker shall not be entitled to claim any compensation. Therefore, in the given case, the contention of the workers of Sunrise Company Limited is not justified and they shall not be entitled to receive any compensation if the tribunal has made an order transferring the services of workers to the transferring companies, that is Moonlight. અગર ટ્રાન્સફરની ઓર્ડર ટ્રિબ્યુનલે આપી દીધો કે તમે બધા વર્કર્સ પેલામાં જ ચાલ્યા જાઓ તો પછી તમે ક્લેમ નહીં કરી શકો, તમે કંઈ જ નહીં કરી શકો. પણ અગર એવું નથી થયું તો તમે કરી શકો. ટ્રિબ્યુનલે ઓર્ડર પાસ નહીં કર્યો તો થઈ શકશે. Practical question 6. HPCL Limited for a number of years was in various types of business. In order to exit from its non-core business, its management decided to hive off the business of food processing by demerging the said business with an associate company, namely BCD Limited. You are required to advise briefly with reference to the provision of the Companies Act 2013 the steps the management should take to give effect to the proposed demerger. An application shall be, as per Section 232, the procedure to be followed by to give effect to a scheme of demerger is as follows. An application shall be made to under Section 230 for sanctioning compromise, and it shall be shown to the tribunal that under the scheme of the undertaking, property or liabilities of the company is proposed to be divided among and transferred. Purchase consideration આદા આખું પેલું જે વાંચ્યું હોય તે બધું છાપી દેવાનું છે, આખો સેક્શન જ છે. ચલો, practical question 7. Answer the following with reference to a scheme of amalgamation of companies, explaining the relevant provisions of the Companies Act. What is the majority required for approving the scheme of amalgamation? Is the scheme to be approved by preferential holders? When will the tribunal order dissolution? As per Section 2, the majority representing 3/4 in value by postage, it must be noted that members who are not in present. Okay, external member includes the preferential holders also. Thus, the scheme has to be approved by the preferential holders as well. And if the meeting of shareholders of preferential holders and equity shareholders are ordered by the tribunal to be held separately, then the scheme shall be approved by preferential holders and equity shareholders in the separate meeting. As per Section 232, the tribunal may order dissolution without any winding up of any transfer company if the tribunal is satisfied that the procedure specified under Section 232 has been complied with. May order dissolution without any winding up of any transfer company if the tribunal is satisfied that the procedure specified under has been complied. Okay, dissolution કરાઈ શકે without winding up, એ બી ચાલી શકે. When will the tribunal order dissolution of the company? As per the tribunal may order dissolution without winding up of any transfer company if the tribunal is satisfied that the procedure has been complied with. એટલે જો tribunal લાગતું હોય કે dissolution થી કામ થઈ જશે તો એ dissolution બી કરાઈ શકે છે. ચાલો, practical question 8. Examining the relevant provision of the Companies Act 2013, answer whether the company seeking sanction of the tribunal for a scheme of amalgamation must have specific power to amalgamate in the object clause of the memorandum. To amalgamate with another company is a power of the company and not an object of the company. Further, a statutory right to amalgamate has been conferred under Section 232 of the Companies Act. Since such statutory provision itself allows amalgamation, no special power in the object clause of the memorandum is required for amalgamation of companies. Section 232 is a complete code which gives full jurisdiction to the tribunal to sanction amalgamation of companies, even though there may be no power in the object clause of the memorandum. Therefore, no specific power to amalgamate is required in the object clause of the memorandum of a company before making an application to the tribunal for effecting the amalgamation. Practical question 9. Pioneer Textile Limited desires to amalgamate its enterprise with Latex Textiles Limited. A scheme of amalgamation for this purpose was approved by an overwhelming majority of shareholders and all the creditors of the companies at meetings held under the provisions of Section 232 of the Companies Act 2013. Thereupon, it was presented to the Company Law Tribunal for its sanction. While the scheme was pending in the tribunal, Some of the dissension shareholders of Pioneer Textile Limited requisitioned an EOGM meeting to negotiate with latex as according to the requisition the exchange ratio was not fair and reasonable. Examine whether I may refuse to call the EOGM करावी पड़શે અને also discuss the power of tribunal. Okay, as the section is made by the eligible members, the board bound to call an EOGM to consider and pass such matters and resolutions. Eligible members in case of a company having a private share capital is means one or more members holding at least one tenth of the paid up share capital of the company. In the given case, assuming that the requisite number of members are present, the AGM meeting as well as the other conditions section of are also fulfilled. The directors are duly bound to summon the extraordinary general meeting. In Praveen Kantilal Vakil versus Mrs. Rohini Ramesh Save, it was held that it is not legitimate to call an extraordinary general meeting for the purpose of withdrawing the petition pending before the tribunal for sanctioning the scheme of amalgamation or to pass a resolution to examine any alternative scheme. However, where an EOGM meeting is called for passing a resolution to renegotiate only a specific matter in the scheme of amalgamation, that is the exchange issue, it is clear that the requisitioning shareholders are not contemplating to withdraw the scheme or even examining any alternative scheme. Further, the tribunal may wide powers under Section 232 and it can modify the scheme already approved by an overwhelming majority as it may consider necessary for the proper working of the scheme. Thus, the directors of the tribunal shall not refuse to call the EOGM. The tribunal is empowered to sanction the scheme of and make provisions for all such matters that are contained in Section 232. Example, transfer of undertaking or liabilities of the company, transfer of making. Okay, since the scheme of has been approved by overwhelming majority, unless it is established that the exchange ratio is grossly unfair or that such scheme of amalgamation is not in public interest, the tribunal shall not reject the scheme. Practical question 10. ABC Limited is a wholly owned subsidiary of XYZ Limited. The company wants to make application for merger of holding and subsidiary under Section 232. The CS of the XY is of the opinion that the company cannot apply for merger as per Section 232 in the contention. Okay, apelo, faster call. However, it should be noted that the company is eligible for merger. Okay, in the given case, and ABC Limited are eligible to merge as per Section 233, but it is totally valid if they opt to merge as per the procedure given in Section 232 instead of Section 230. Thus, the contention of the company secretary is not valid. Cannot apply for merger. Okay, કરી શકે ઓપ્શનલ છે કે મેન્ડેટરી થોડી છે કે કરો જ ભાઈ તમારી ઉપર છે કરવો હોય તો કરો ફાસ્ટેગ આપ્યું છે નહીં કરવું હોય તો નહીં કરો તમારા બાપાનું છે મા બાપાના ચૂલામાં શું પડવાનું છે પ્રેક્ટિકલ ક્વેશ્ચન 11 Mrs. Unicorn Rubber Sheets Limited is incorporated and registered in the United Kingdom. UK માં છે ભાઈ Mrs. Arthur Rubber Sheets Manufacturing Trading Limited is an Indian company incorporated and registered under the provisions of Companies Act 2013. A scheme of compromise between the above two companies provided for an amalgamation of the English company with the Indian company. Okay, the CFO of the Indian company is of the opinion that the companies being amalgamated must be companies registered in India, and therefore an amalgamation with a company registered outside India is not possible. Section 234 the Kaido explain the provisions. Okay, company under the foreign company after obtaining Reserve Bank after complying with the provisions. Okay, for the company may merge with a foreign company in any of the specified by central government. They notified the jurisdiction of the application for obtaining the approval of the as per the provision of section 230 and 232 shall be filed after obtaining the approval of the RBI. Okay, therefore the container CF that the companies being amalgamated must be companies registered in India is not correct. कोई भी company, कोई भी foreign company, कहीं भी इंडिया ની બહાર ની કરે બહારથી ઇન્ડિયા વાળી કરે કોઈ બી ચાલે વાંધો નથી આપણા પપ્પાનું કઈ નહીં બગાડતું અમેન્ડમેન્ટ કરો તમારું છે તમારા પૈસા તમારા બાપાનું જોવાનું મારે શું કરો ખાલી આરબીઆઈ ના જે પ્રિસ્ક્રાઇબ નેશન છે તેમાંથી જ કરી દો અને એકવાર 230 to 232 જોઈ લેજો ભાઈ કમ્પ્લાય કરવાના છે એને એમ નથી કે ચાલો ભાઈ છોડ દો જવા દો એવું નથી કરવાનું ચાલો પ્રેક્ટિકલ ક્વેશ્ચન આવી ગયો 12મું ચાલો. As part of amalgamation, Harsha Limited acquired 90% of the issued capital of Ananya Limited. Harsha Ananya નું લીધું. વાહ. The issued, subscribed and paid up capital of Ananya Limited is rupees 100 crores. Okay, issued and paid up capital 100 crores. Out of the remaining minority shareholding of Ananya Limited, rupees 8 crores held by Mr. Raju. Mr. Raju was not satisfied with the amount decided under the scheme and therefore negotiated for a higher price. As a result, he received an extra amount of rupees 10 lakhs. The other shareholder claimed that it is not entitled to extra rupees 10 lakh examine the validity where the minorities जो provision तो खबर जाए applying to the above provision in the given case Mr. Raju one of the minority shareholders holding share capital of rupees that is he is holding more than 75%. Therefore, as per section 236, the additional company received by Mr. Raju shall be shared with other minority shareholders on pro rata basis. Thus, the claim made by that Mr. Raju is not entitled is valid. કે એ 10 લાખ પોતે એકલો નહીં લઈ જાય કે ભાઈ ડિવાઈડ કર વધારે લઈ ગયું ને તો ડિવાઈડ કર લો ખબર છે 75% થી વધારે where the shares of minor have been acquired in the section and as on the prior date, such as the shareholders holding 75% or more of minority એટલે આજે 10% છે એનું 75% એટલે ટોટલનું 7.5% હોલ્ડ કરતો હોય તો પછી એ કરી શકે. હવે અહીંયા 8 કરોડ કરે છે 100 કરોડમાંથી 8 કરોડ એટલે એ 7.5%થી વધારે થઈ ગયું તો એ એવું કીધું કે ભાઈ મને વધારે પૈસા 10 લાખ આપ હું સેટલમેન્ટ કરી લેવા તો એવું નહીં ચાલે. હવે 10 લાખ લીધા છે તો વાંધો નહીં પણ પેલા બીજા 2 કરોડ વાળા જે છે બીજા 2 કરોડ વાળા જે બીજા બધા બાકી રહે તે લોકોને બી પ્રપોર્શનેટ પ્રો રેટા બેસિસ પર આપજે એવું નહીં એમ તું પોતે ભાગ નહીં લઈ લે બધો આપજે એ લોકોને. ચાલ practical question 13. In a scheme of reconstruction by a multinational company listed in India, the company wanted the minority shareholders to get out of the company by selling the shares back to the promoters at a price determined by the promoters. The minors were not given a choice whether they wanted to tender the shares or not. In the meeting, there were 6 non-promoter shareholders who voted against the scheme, but chairman declared that the motion was carried with an overwhelming majority of more than 90% of shareholding. However, contended that they had a right to reject the offer. Will they succeed? Ooh. If by share exchange, conversion of securities, or any other reason, an acquirer or person acting in concern with such acquirer becomes a registered holder of 90% or more of the issued equity share capital of a company, or any person or group of person becomes 90% majority or holds 90% of the issued equity share capital of a company, such acquirer person or a group of persons shall notify the company of their intention to buy the remaining equity shares. The acquirer person or group of persons shall offer to the minority shareholders of the company for buying the equity shares held by such shareholders at a price determined on the basis of valuation by a registered valuer in accordance with Rule 27. The minority shareholders may agree to sell their shareholding to the majority shareholders. The above provision makes it clear that Section 236 does not compel the minority shareholders to sell their shares. It is at their discretion whether to sell their shares or not. Further, in the given case, the price was determined by the promoters and not the registered valuers. Therefore, in the given case, the contention of the minority shareholders that they have right to reject the offer is legal and valid. એ લોકો પાસે રાઈટ તો છે જ ને કે તમે હું મારે રિજેક્ટ કરવું જોઈએ એવું થોડી કે તમે થોપી દો ને એવી પ્રોમોટર જ થોપે વાહ બેટે તમે મોજ કર દો ऐसा थोड़ी चलेगा. चल practical question 14. CPL Limited and TJC Limited are wholly owned by Government of Tamil Nadu. As a policy matter, the government issued administrative orders for merging TGS and CPL Limited in the public interest. State the authority with whom the application for merger is required to be filed under the provision of Companies Act. Also state the governing the preservation of books and records of TGS Limited. As per Section 237, where the central government is satisfied that it is essential in the public interest that two or more companies should amalgamate, the central government may, by order notified in the official gazette, provide for amalgamation of those companies into a single company with such constitution, with such property powers, rights, interest, authorities, and privileges, and with such liabilities, duties, and obligations as may be specified in an application seeking an order of amalgamation under Section 237 is required to be made to the central government, and if the central government is satisfied that such amalgamation is in public interest, it may make an order of amalgamation notified in the official gazette in accordance with the provisions of Section 237. The provisions governing the books and have been acquired another company under this chapter shall not be disposed or without the permission of the central government. Direct dispose नहीं करता central government ने permission ले लीजिए. Before granting such permission, the government may appoint a person to examine the books and papers or any of them to ascertain whether they contain any evidence of the commission of an offence in connection with promotion or formation of the transfer company, management of the affairs of transfer company, or its amalgamation or the acquisition of its shares. And with that, we are completed with compromise and arrangements question chapter 5.